SJC-11959, Emma Gyulakian v. Lexus of Watertown, and another.
Mr. Mantell, good morning.
Good morning. Again, my name's Rob Mantell. I'm with Lori Jodwin with me, and we proudly represent Emma Gyulakian in her sexual harassment complaint against Lexus of Watertown. Ms. Gyulakian survived 18 months of horrible sexual harassment at the hands of her direct supervisor, the director of the finance department, and one of the top 4 managers in the company.
Now, there are facts, are there not, relating to whether or not other members of the supervisory group were aware of incidents? Was there proof of that?
There was absolutely proof of that. In fact, Ms. Gyulakian testified that she complained many times to Tony Bruno, again, one of the top 4 managers in the company.
But I mean, were people other than Bruno aware of it?
Well, for example, Mr. O'Connell, who was number 2 in the company, saw Ms. Gyulakian, Mr. Ferreira, throwing coins at her chest. And for example, Mr. Skolnick, who was then number 2 in the company, heard Mr. Ferreira making derogatory statements about women's bodies in the workplace. He didn't discipline him. He didn't tell him to stop. But under the law, once a member of the supervisory staff knows, then the employer is on the hook. Under the negligence standard, under vicarious liability, they're on the hook based on Ferreira's conduct itself. But they knew.
Well, they knew, so you're saying there's direct liability here, not vicarious liability.
There is both.
In spite of...
There is vicarious liability and there's direct
vicarious liability is a given. Direct liability is what you say exists here, and that was established?
Both of them exist here and
that is
and
the basis. Okay, understood. Direct liability, you say, is established in the record based on the judge's findings, direct liability?
Well, the judge found against, well, yes, the judge found direct liability for the purposes of compensatory damages, but not for punitive damages.
For purposes of compensatory damages?
Absolutely. The judge found...
And direct liability?
Correct. The judge denied JNOV, denied a motion for new trial, and denied remittitor, finding direct liability.
But she eliminated the punitive damages because she essentially concluded that they didn't attach to vicarious liability.
That's correct.
But she didn't. She wasn't the compensatory damages. Didn't she find that they were based on the vicarious liability under Collegetown?
She did not identify one way or the other whether it was under the vicarious liability or under direct liability that the emotional distress damages were found.
Okay, but so she didn't, in any event, she didn't actually specifically find direct liability for compensatory damages.
I suppose that's right, but we don't know which one she found under.
If I can step back, this distinction between vicarious and direct, direct liability, as I understand it, applies only when the individual who is engaged in the sexual harassment is not a supervisor.
Properly understood, that's correct.
And therefore, one must look to the conduct of those who knew of it and failed to act as their conduct. But isn't it essentially vicarious liability for their conduct? I mean, it's ultimately vicarious liability. It's just a question of who were the superiors.
Properly understood, vicarious liability is the employer is responsible for the conduct of supervisors who are vested with authority, such as Mr. Ferreira. Direct liability is only for lower-level coworkers harassing the individual, and then the employer is somehow aware. In theory, we don't even have to get to direct liability because there is vicarious liability in this situation. But here we have even more, which is constant complaints many times to someone very high in the company who supervised 30 individuals or more.
Was there any evidence at trial as to why, given the directions in the sexual harassment guidelines, to whom this is to be reported, was there any evidence about why your client didn't complain to the the two people that were named, or one of the two people that were named in the policy?
There are many people named in the policy. The policy says you may complain to the HR person, to the general manager, or any manager that you prefer. So her complaints to the assistant general sales manager, second or third highest person
So
in the
it's
company.
not just the
was
HR manager and the general manager?
Correct. She completely compliant with the policy to a person vested with the responsibility of receiving such complaints. That's in writing. And again, there's no obligation that those complaints be in writing. She complained in compliance with the policy.
Now, if we can go back to the vicarious liability, what have we defined what constitutes a supervisor for whom vicarious liability applies?
Yes. It's someone with supervisory authority, someone vested with supervisory authority, which is someone, if you understand the nature of 151B itself and the theory of sexual harassment, it's the alteration of the objective terms and conditions of employment. So someone vested with the authority to alter the terms and conditions of employment is thereby acting within the scope of their employment and altering those conditions. That's the only way liability is established. And
Now,
so,
does that mean they have the power to fire, or simply
No.
that they are involved in day-to-day
No.
supervision?
the many cases that I cite in my brief say that the manager need only have input into the decisions to hire and fire and need only have responsibility over the conditions of employment. Here, there's no question that Mr. Ferreira had responsibility over the entirety of the conditions of employment. And the one thing that I want to bring out today, my priority today, is to alert you to the Melnichenko case, which is 424 Mass, page 294. And in that case, and on that page, it said that the following conduct took place within the scope of employment. A supervisor announced to coworkers that a subordinate, that he was having sex with the subordinate, and that he had sex with the subordinate a number of times, and that the subordinate was injured based on the amount of sex that he had. This court in 1997 held that that supervisor was acting within the scope of employment, cited to Collegetown, understanding that sexual harassment is all about altering the conditions of employment. Then the next year, knowing that, next year the legislature amended 151B to add entitlement to punitive damages. So the common law standard for awarding punitive damages is a managerial agent acting within the scope of employment. This court established that sexual harassment takes place within the scope of employment. The First Circuit has done well, the Monteguito case and the Arrieta case. So therefore, even under the common law standard, punitive damages apply in this case. Now, let's talk about the liberal construction of 151B. To the extent that the legislature assumed that the common law informs interpretation of 151B, the liberal construction requirement contained in Section 9 requires this court to choose the broadest, widest remedial strains of common law out there. Here we have this court's decision in Melnichenko, the Monteguito case, and the Arrieta case, saying supervisory harassment occurring in the workplace is within the scope of employment, therefore placing this squarely within the common law notion of when punitive damages are permitted.
But you're resting on the statute primarily. You're saying the statute provides for punitive damages based on supervisory authority.
I believe so, and I believe the statute is broader than common law, but even if common law is considered, you have to take the most liberal version of common law that you can find. And here, it was established in Melnichenko a year before punitive damages were adopted.
Now, do you agree with the defendant that Mr. Ferrara only had 2 employees under his direction?
Mr. Ferreira had 3 to 4 employees under direction, but the evidence in the case was that he gave, there were many people below him, okay? So he might not have direct supervisory authority, but there were many people below him. He was the director of the finance department. He was in charge of funding for the entire company, and the general manager, Vincent Liuzzi, said that he was one of the top 4 senior managers in the whole company.
So are we talking about the difference between direct reports and position in the company? I'm not really sure I understand what you're saying.
Okay, so there were 3 or 4 direct reports to Mr. Ferrera while he was director of,
These are people on an equal level with your client? The
including
three-
my client.
Right. But,
Yes.
I mean, they're all finance.
Yeah, he was a director of the finance department. She was a finance manager. She reported to him.
And did people report to the finance managers?
No,
Okay, so you say there are lots of people below him, but he didn't have authority over them?
there's receptionists, there's people, pushing paper around. He's above them, and he has seniority.
Above them, but they don't report to him, and he
They
doesn't
don't
have,
report
he doesn't have
directly to
control
him.
over their
Terms and conditions of employment.
right? I mean, he doesn't have.
Well, I would say that he does. The vicarious liability standard does not require direct report, by the way, and all the cases say that.
Okay.
But he had a very important role within the company. It's unquestioned that he was one of the top 4 people, top 4 highest managers in the company. That's the evidence that the jury was entitled to believe, and that's what you have to accept at this point, because JNOV is really the only vehicle that we're here. Again, remitted or a new trial were denied in this case.
So your response to the argument, well, geez, if you do vicarious liability for punitive damages, what is that going to do with compliance with Section 3A? Is, well, there was full compliance with Section 3A. That's what you say.
Well, okay. So Section 3A says that an employer must produce a policy regarding sexual harassment and circulate it. But it also says that doing so will not create a defense to liability. It's a direct contradiction to Kolstad, okay? So Section 3A was enacted in 1996, and it specifically dispensed with the idea that simply going through the boilerplate and cutting and pasting policies is going to insulate you from liability. In this case, the policy was non-compliant, by the way, because it did not identify what supervisors such as Bruno should have done had they received complaints of discrimination. Now, if you look at the MCAD guidelines, it says that should be in there, but it wasn't in there, and so Bruno didn't report it up. Nothing happened to Ferrera, and the hostility and harassment continued. But there are many reasons why Kolstad should not be adopted in this case. One is the idea that Kolstad should apply was waived by Lexus of Watertown. 2,
Remind me why it's waived?
because they didn't file a motion for directed verdict,
Right.
okay?
But on that point, though, there wasn't a separate. Well, explain that, because it seems to me that was there a question about? The argument is that it was really going to be, it was on the verdict slip where the objection was made, that it wasn't a separate, isn't that right? Isn't that what the defendants argued?
After the jury was charged and sent out to deliberate, we had discussions about the form of the verdict slip.
Right.
Should there be one blank for punitive damages, or 3 representing the 3 separate counts? And they said, no, it should be 1 and not 3, and there was back and forth. After the jury was sent out, then they raised this issue of vicarious liability is not sufficient to warrant punitive damages. But their own jury instructions, their own proposed jury instructions, permitted punitive damages based on vicarious liability. Their own instruction says the conduct of the supervisor binds the company, and you can award punitive damages against the company if you find outrageous conduct warranting punishment and condemnation. And by the way, the jury had all the evidence here. They had all the evidence, the policies, the alleged trainings, the alleged investigations that did not happen, were complete sham. But they had all that evidence brought in to help them, and the jury was told to consider all the nature and character of the conduct. And they rejected the idea that there was good faith here. And here's a big problem with the decision below, is the judge improperly found facts. The judge said that the defendant investigated immediately. Completely not true. The people who allegedly were investigated and interviewed said, we were not investigated and interviewed. And she said that the investigation corroborated the fact that there was nothing there. But we were not allowed to discover whether there was corroboration or not. The defendant said the investigation was attorney-client privilege. Everything about the investigation is privileged. You're not allowed to discover what was asked to the witnesses, what the witnesses answered. There was no, we weren't even allowed to ask whether there was a written report in concluding the investigation. And so the idea that the judge arrived at the decision that, that there was no corroboration of Gyulakian is completely unfounded.
I'm afraid
well,
I'm
yeah.
afraid your time is up.
I'd like to rest on the other defenses in my brief.
Great, thank you.
Thank you.
Mr. Sullivan, good morning.
Good morning, Your Honors. Chris Sullivan on behalf of the appellee Lexus. I'd like to take up, if I could, just where the discussion had started, particularly with your question, Judge Botsford, about whether or not the sexual harassment policy that was in place at the time of this incident was in fact followed. The policy provided that if there was going to be a complaint for sexual harassment, it should be sent to the general manager or to the human resources manager, Mr. Liuzzi, or to...
The language, could you read the language of the policy that you're referring to, please?
And this is on the second page. Any employee who believes she has been sexually harassed or retaliated against for complaining of sexual harassment should report the situation to either Tim Rinaldi or the human resources manager who's been designated to receive such complaints. If an employee prefers not to discuss the matter with these individuals, she may go directly to any other member of management. Now,
Right.
Tim Rinaldi was the
So
predecessor.
The second sentence is key, isn't it?
It is, and I was going to get to that, Judge, and to complete my point, is that at the time of trial, there was testimony by Mr. Liuzzi and Ms. Brown, is that this option of going to other managers was there for the reason if they were unavailable, if it was a
And
weekend.
it doesn't say that. It doesn't say if they're unavailable.
It
says
doesn't say in the policy, but they testified to how the policy was implemented and was put into practice at Lexus. And the
You're saying that that was announced to employees in some writing, that there was an, so you have a written policy, but you have an oral exception?
well, it's not an exception, it's more of an explanation.
Oh,
that they.
please.
It says
They-
if prefers,
It does say that.
right.
But the testimony of both Ms. Brown and Mr. Liuzzi at the time of trial was that the implementation of this was they expected to receive within 24 hours, if another manager was contacted when they were unavailable, to get a verbal report from that manager, and that they would have something in writing as a follow-up. And the
How would
reason was
employees know this?
because they were told. They had sexual harassment training on an annual basis. There was a written sexual harassment
There was
policy.
evidence that in that sexual harassment training, specifically what you're just saying was told to all the employees?
The testimony of Mr. Liuzzi was that there was sexual
He do the
harassment training
training? Did
about
he-
the policy, did not specifically say that specific aspect, that specific subtlety to it.
Well, couldn't the jury or a fact finder say, I'm looking at what's written here and I'm listening
Correct.
to what these guys are saying and I don't believe what these guys are saying, I'm going with what's written?
That's true, they very well could. But that was uncontradicted at the time of trial, that this
Well,
was.
so what?
I'm sorry, Judge?
So what? I said very rudely, I apologize.
That's okay, Judge.
but
I understand.
the,
This is argument, but, well, the so what part of it is that this was the policy, how it was implemented, and that at the time of trial, when this was testified to, was completely uncontradicted. So the jury could believe or disbelieve anything that the witnesses had to say. But the fact is that the policy itself wasn't just the written portion of it. The reason why there's that exception to go to another manager is if you're uncomfortable going to the general manager or to the human resources manager, that you can go to another manager. But they would expect to get some information, because how could they possibly investigate any type of complaint if they couldn't get something?
but wouldn't that be the responsibility of the person to whom the complaint was made? Why should she be responsible for the fact that Mr. Bruno didn't do what he was apparently supposed to do?
Correct. It's not the burden would not be on the person making the complaint. The burden would be on that other individual who received it, and this is what they would expect, to be able to get information so they could investigate the claim. And the record was clear that Mr. Bruno, who received these complaints, and he denied them at the time of trial, and there was no other witness that corroborated this at all.
He denied having received the complaints?
Oh, absolutely.
And so she testified to the contrary,
She did.
and they obviously believed her.
Well, Judge, I don't know exactly what they believed. The fact is that no other witness out of the other dozen or 2 dozen witnesses that testified corroborated that anything ever went by or forward from Ms. Gyulakian to Mr. Bruno to anyone in upper-level management, because Mr. Bruno was not upper-level management. He had salesmen directly and salespersons directly underneath him. Above him, he reported to Mr. O'Connell. Mr. O'Connell, who was the general sales manager, reported to Vin Liuzzi, the general manager, and general manager reported to the owner, Murray Patkin. So he was...
Mr. Sullivan, the bigger the company, the more insulated it is from vicarious liability, because you can add the layers about who's supposed to talk to whom, to whom, to whom?
Well, I think at some point there has to be a line of communication. I agree, there's no insulation. But what I'm trying to point out is that to say that Mr. Bruno was upper-level management is inaccurate. He was not a decision maker. He was not a policy maker. The people that reported to him were the rank-and-file sales force. He then had at least 2 levels of authority before you got to somebody who was the general manager, Mr. Liuzzi. And that's important because when we take the self-serving statement of the plaintiff that I did complain, even though the plaintiff had worked for 9 years at this dealership with Mr. Ferreira, never once had a complaint in writing, never once had a verbal complaint that was verified by anybody, and it's uncontested, Mr. Bruno never said a word about this to anyone.
But if the written policy, as amended by this oral exception, is something that essentially falls on the shoulders of the company, this is the company policy. Why isn't it enough that the complaint was made to the guy that it was made to? He was an approved receptor of complaints for sexual harassment. Why isn't that enough to establish vicarious liability?
Well,
That's the company's policy.
it would be enough to establish vicarious liability for compensatory damages. But when we get to the issue of punitive damages, which is an extraordinary measure, and before that type of punitive damages analysis is done, you need something more than just...
Yeah, so the company can say, we're going to refer all claims of sexual harassment to the janitor. The janitor sweeps them into a bucket, and that's the end of punitive damages, under that theory.
But if you have a policy like this that was implemented requiring a follow-up, requiring that upper-level management is contacted, requiring something in writing so that they can investigate this, then I don't think that hypothetical would be accurate, because you would have some information that would be able to corroborate the complaint so that you could investigate it.
Assume that she made the complaints to Bruno. Assume that the jury believed that she made the complaints to Bruno, and it was Bruno who failed to pass them along or do anything about them. She should pay the price of that? That's the
In the case
analysis?
of punitive damages, yes, because punitive...
How is she supposed to guarantee that under your written policy, it says that she could, in fact, complain to somebody like Bruno. And if she did, then it's her undoing that Bruno didn't do what he was supposed to do under your unwritten policy.
In the context of punitive damages, yes. I think there's got to be a line that's drawn in fairness to balancing the interests of the employees
How is that
and the
balancing
employers.
her interests against the company's?
Well, because in the context of vicarious liability for punitive damages, there has to be something more than just an unverified verbal complaint to somebody who's not listed as the genuine and original designee of complaints.
How do you get to that point if the person who is supposed to pass it on to be able to have that investigation doesn't do the job?
And when that individual doesn't do that job, what are the implications of that?
If Bruno didn't do the job that, let's assume, he was required to do in order to trigger the investigation of what was it could in some other case, or in this case, have been a baseless accusation of sexual harassment? Is that what you're suggesting? How do you get to the investigation part?
I think you need something more than just one verbal complaint to somebody who's a mid-level manager like Mr. Bruno.
So what you're saying is that just because, assuming she made one complaint assuming it was the right person, still not enough.
Yes,
It was
Judge.
just one complaint.
To affix punitive damages liability to
So
an
what would she have
employer.
done? She should have done what to get to that level of this is enough
Well,
under the
one-
law?
what she should have done was to have complained to the designated people who were actually identified by their
Let's say
positions.
he's the designated person. That's, we're dealing with the hypothetical of he's the right one and it was his job to continue. And you're saying, well, even if he had been the right one, gee, there wasn't enough in what she said. Isn't that what you're saying under the hypothetical?
Correct. There
So
should have
what would
been-
have been enough for her?
The policy is implemented required that there should have been follow-up in writing from the complaining witness, and then the person receiving the complaint, the manager, should have at least within 24 hours notified the correct people, which is the
So the
general
policy
manager
says
or the
that
human
once you
resources manager.
verbally notify your designated preferred person, here Bruno, you must then follow that up before anybody does anything with something in writing that sets forth all the bases for your complaint.
Yes, so that they
Where
can
does it
properly
say that?
investigate.
Well, where does it say that?
Where does it say that in the policy?
It doesn't say it in the
Oh,
written
it's all
policy
the oral exception to the policy.
as it's implemented and as was testified to at
And the
trial.
jury could have disbelieved.
That's correct. They could have
Well,
disbelieved it,
let me
absolutely.
ask you that, but I understand there was testimony that there was training, but did it get to the specifics of this?
It's unclear in the record whether they got to the specifics of this in the training.
Well, isn't that pretty important if you're going to rely on it?
It is important. I can only tell you what the evidence is in the record, and I don't want to in any
I'm
way
sorry, yeah.
misrepresent what was in the record. The testimony was they had annual sexual harassment training concerning the policy. The testimony was not into the minutia of the policy about why or how this specific issue was raised in the training.
So
But-
I'm sorry, so your position is that Mr. Ferrara was a high enough level manager that the company was vicariously liable for his conduct with regard to compensatory damages. Do you agree with that?
Yes, under College Town, yes.
Okay, but that something that they're vicariously liable only for an upper level manager beyond him for punitives?
Yes, because when we take a look at the restatement or we take a look at traditional common law agency principles, somebody who is acting within the scope of their employment has to be in a truly managerial capacity. Mr. Ferrara, who did, by the way, only supervised two other people besides Ms. Gyulakian, is not of that level of a managerial capacity. He's not a decision maker. And furthermore, he was not acting in the scope of his employment. Sexual harassment, when someone acts on their personal...
That would apply to compensatory too. But if that's the case, no one who engages in sexual harassment is acting within the scope of their employment, because of course it's not within the scope of their employment to be
Sexually harassing.
sexually harassing. So I mean, by that standard, the corporation's never liable.
It's correct, but we have to draw a line, I think, between compensatory damages and punitives.
Okay,
because
but did
of-
you ever ask? Was a jury ever told that you may find him vicariously liable for that the corporation is responsible for Mr. Ferrara's conduct with regard to compensatory, but in order to find the corporation responsible for punitive damages, you must find something different? Did you ever ask the jury to be instructed?
No, and vicarious liability was not brought up at all in the instructions.
Well, I assume there was something in the instruction that said the corporation is responsible for certain person's conduct, was there not?
I can't give you a quote from the instructions.
So,
The
I mean, come
instructions-
on, I mean, you're here on this, I'm sure the word vicarious was not used.
It was not used.
But
I
I
know
assume
that,
that the
Judge, and I can
judge
represent
told
that.
the jury the corporation is responsible for the conduct of somebody who you find to be a manager. Did she not give that
I
instruction?
believe there was an instruction.
Did you ever
similar-
ask for an instruction that said, but with regard to punitive damages, there is a different standard that should be employed?
No.
So
no,
how
Judge.
could you come here and say that a different standard should be employed when when you never asked that the jury be instructed in their evaluation of whether punitive damages are appropriate?
Because at the time of trial, Judge, our reading of the law was that there was not an ability to find punitive damages for vicarious liability in Massachusetts. So we did not ask for jury instruction on that issue.
But
I
wouldn't
take
you,
it you objected to the verdict slip based on the fact that punitive damages were included, and they shouldn't have been included.
no.
We objected to two portions of the punitive damages issue. First was the verdict slip in terms of multi-level questions of punitive damages for each count, but we also objected and didn't bring up the vicarious liability in a long discussion with Judge Budd about there should not be any vicarious liability allowed for this defendant, and we.
Oh,
if you
that's,
look at-
and she footnotes that in her
Yes, we did
opinion,
have that
That
discussion.
you raised this issue.
We did raise it,
directly.
Judge. And in fact, she responded by saying that, well, we're going to go forward on this issue, and in the event there's an adverse verdict, you can come back and
Right.
see me. So there was no question that that issue was raised. It was not waived. It may not be as articulate as it could have been at the time of the conference, but in reality, it was brought up before the jury reached its verdict. In fact, we were working on the verdict slip while the jury was still out, making changes to it, continuing with our instructions.
So let me ask you, what level of manager is sufficient for the corporation to be responsible for their conduct?
For punitive damages, Judge, it would be a decision-making manager, somebody who was high-level, a policy-making manager, not a low-level individual who was supervising 3 people out of 100 to 40 to 50 person workforce.
But I gather that this person was responsible for all of the financing of every car that was to be purchased at the Lexus of Watertown.
His title, so that I think this is helpful to give you a little flavor of the trial, he was called a director, but in reality, it was just a title. He simply supervised 3 people.
Okay, try my question. Was he responsible for the financing of every car that was purchased at Lexus of Watertown?
I would say yes, indirectly. His deals, as they came in, he would approve them, but then they had to be approved by the general sales manager before they left. So he was close, but he was not the final arbiter. The general sales manager would approve the deal.
Was there evidence that the general sales manager or the general manager, and I'm not going to get the titles completely right, but did say he was one of the 4 top managers of the company?
He did refer to him as not top, but he referred to them as senior. Mr. Ferreira had been there for 20 years without any complaints
But
from
one
anyone.
of 4, yeah, but there may be other employees who have been there 20 years. One of 4 top managers?
He referred to him as senior managers.
One of 4 senior managers?
Correct. He did say that, Mr. Liuzzi, but keep in mind, this is your traditional auto dealership. The head management is the head of parts, the head of sales, the head of service, and then you have the general manager who's above them that runs them all. Then below them, you have other individuals like Mr. Bruno.
But wouldn't, I guess, assuming the correctness of that analysis of the business, wouldn't there need to be evidence that this is the way this business works? And so the title of you'd have to put in evidence that this company is different from most companies, where if you hear that you've got 4 senior managers, one would think that they are the top management of the company.
Well, when Mr. Liuzzi answered that question at the time of trial, I think he was referring to the fact, in part, that he had been there 20 years between this dealership and another dealership down the road, Toyota of Watertown, that were owned by the same individual. He had been there for a long time. He was senior, but when you look at the authority structure, he was not a policy-making individual at all. He was not a decision-making individual at all. In fact, Mr. Liuzzi recommended Ms. Gyulakian for the position in the F&I insurance department, and he did consult with Mr. Ferreira, but it was Mr. Liuzzi who was the one who recommended her for that
So who in that
position.
organization is high enough? What's the lowest level high enough person in that organization to whom complaint should have been made to expose Lexus to liability for punitive damages on your theory?
Using an agency analysis of someone with true managerial capacity, it would be one of the top managers within each department of the dealership. Parts, sales, service.
So here. Finance? Yeah.
Finance was not a separate, they were underneath sales. They did not reach that level at all. They were part of the sales department.
So who is it that she should have complained to if she wanted punitive damages?
She should have complained to either the people that were specifically referenced in the policy or to one of those top managers who run their departments.
So who, that has to be the head of sales?
Correct, and that would have been Mr. O'Connell.
So, okay, Mr. O'Connell saw something, though. Isn't he the one?
Well, Mr. O'Connell denied seeing anything. The testimony was that he was in a room when
He's the one
the
who
pennies were
got
being
red
thrown.
he's the penny guy.
And then
There's
he
somebody with
walked
a red
out of the
face.
room. It was one of these, either over the shoulder and walking out of the rooms, said nothing. It was very tangential evidence at the time of trial. But the issue that this court was looking at as to whether or not to adopt a Kolstad good faith defense, I would like to make the point to the court that that is a balancing of the employee's interest and the employer's interest, and it does provide for an incentive for employers to be able to comply with 151B. Similar to what the Supreme Court said in Kolstad, If you have an employer who has a written sexual harassment policy, who has annual sexual harassment training, who enforces the policy, and who also has good faith investigation, all of these things Lexus did.
All right,
Keep
I'm
in
afraid-
mind that when
I'm a-
Mr.
I'm afraid your time is up, and that argument's been made in the brief, and we shall consider it.
All right, thank you, Your Honors.